New Mexico Broker Basics, page 24. 5. Written disclosure of any adverse material facts actually known by the associate broker or qualifying broker about the property or the transaction, or about the financial ability of the parties to the transaction to complete the transaction. Adverse material facts requiring disclosure do not include any information covered by federal fair housing laws or the New Mexico Human Rights Act. B. In addition to the broker duties owed to prospective buyers, sellers, landlords, owners, and tenants as set forth in the section 16 period 61 period 19 period 8a, brokers owe the following broker duties to the buyers, sellers, landlord, owners, and tenants to whom the broker is directly providing real estate services, regardless of the scope and nature of those services. Brokers working as property managers for a landlord, owner, are directly providing real estate services to the landlord, owner, not to the tenant. 1. Assistance to the party in completing the transaction, unless otherwise agreed to in writing by the party to whom the broker is directly providing real estate services, including A. Timely presentation of and response to all offers or counter offers, and B. Active participation in assisting in complying with the terms and conditions of the contract and with the finalization of the transaction. If the broker in the transaction is not providing the service, advice, or assistance described in paragraphs A and B of this subsection B of 16 period 61 period 19 period 8 NMAC, the party must agree in writing that the broker is not expected to provide such service, advice, or assistance. 2. Acknowledgement by the broker that there may be matters related to the transaction that are outside the broker's knowledge or expertise, and that the broker will suggest that the party seek expert advice on these matters. 3. Advice to consult with an attorney regarding the effectiveness, validity, or consequences of any written document generated by the brokerage or presented to the party, and that has the potential to become an express written agreement. 4. Prompt accounting for all money or property received by the broker. 5. Maintenance of any confidential information learned in the course of any prior agency relationship, unless the disclosure is with the former principal's written consent or is required by law. 6. Written disclosure of brokerage relationship options available in New Mexico. 7. Unless otherwise authorized in writing, a broker who is directly providing real estate services to a seller/owner shall not disclose the following to the buyer/tenant in a transaction. C. That the seller/owner has previously indicated they will accept a sales/lease price less than the asking or listed price of a property. D. That the seller/owner will agree to financing terms other than those offered. E. The seller/owner's motivations for selling/leasing, or F. Any other information the seller/owner has requested in writing remain confidential unless disclosure is required by law. 8. Unless otherwise authorized in writing, a broker who is directly providing real estate services to a buyer/tenant shall not disclose the following to the seller/owner in the transaction. A. That the buyer/tenant has previously indicated they will pay a price greater than the price submitted in a written offer.